rebuttal.
3 minutes, yes, sir.
Your Honor, this case, just a little factual background, started off, and right as the pandemic was taking off, we filed a lawsuit in May 2020, and we were involved in the discovery. Discovery had taken place, and we were...
Just so I'm clear, Mrs. Cunningham was injured on May 25th, 2019? Is that correct?
Yes, sir.
Okay.
And we were involved in the discovery, completed plaintiff's response to discovery, and we lost contact with our client and was unable to reach her. And then through somewhat investigative work, we were able to find out that she had died, and we did not have any names of any of her heirs, so we then had to start looking for the heirs of Mrs. Cunningham. And we, in that, something that has never been done, in my office, is that we file a notice of death.
Let me ask you, I'm curious about that, and I've seen this happen before. As a plaintiff, your client passes, why would you ever file a suggestion of death unless you're prepared to meet that 90-day requirement in the rule?
Well, Your Honor, we could
because
not...
it's the filing that triggered the necessity to substitute.
Yes.
You don't file, defendant doesn't file, you do nothing.
I understand. Your Honor, we were involved in the scheduling order, and I had a new paralegal, and we can't, argue that that was an excuse, who took the initiative to file the suggestion of death. And we had to find...
I'm sorry, what's the connection between the scheduling order and filing the suggestion?
Well, in that, we felt compelled to keep the case moving. And that was one of the things that my paralegal took it upon herself to file the suggestion of death. And without diaring the 90-day requirement. And that, Your Honor, what we did was, once we filed the heirs, prepared a petition to open an estate, and that we're looking at this particular case, even with the suggestion of death, we still needed to have a client, a party. So when we found the heirs of Mrs. Cunningham, we filed the petition, opened up an estate. In that, and I've been practicing here in Davidson County for 30 years, and never has it taken such a long time to get a petition on the docket. And I wasn't informed that this petition was beyond the 90 days, that we were going to have a hearing beyond the 90 days. And once it became, to my attention that we were going to be beyond the 90 days, I did file a motion for extension of time. In that, Your Honor, we were not sitting back strategically trying to wait on the 90 days. We did something. We basically filed a petition to get a party before the court, in that opening up the estate, because if we don't have a party to open up an estate, we would have to ask the court to appoint a public guardian for the estate.
But none of that was done within the 90-day period.
In terms of, no, Your Honor, it wasn't.
You didn't ask for a public guardian. As I understand it, you didn't even ask for an extension until the 90 days was up. Is that correct?
Yes, Your Honor, but we filed a petition, and I'm thinking that, all right, that is an act to open up the estate, and when the date for the open up the estate or the hearing was way beyond the 90 days, I presume that was least would have given some merit to our good faith efforts to keep this case moving. So, yeah, Your Honor, yes, Rule 25 clearly directs dismissal of an action if no motion for substitution of a party is made within 90 days after the suggestion of death upon the record. However, 6.02 of the Tennessee Rules of Civil Procedure grants trial judges discretion to enlarge many of the procedural time limits prescribed by rules of civil procedure. When by statute of these rules or by notice given thereunder, or an order of the court is required to allow something to be done within a specific time, the court cause shown may at any time act upon its discretion, with or without a motion. Upon a motion being made after the expiration of a specific period, permit the act to be done where the failure was the result of excusable neglect, Your Honor. And we're asserting that there was an excusable neglect relative to this matter in light of the fact that never has it taken more than almost over 60 days, almost 90 days for a matter to get on the docket, in that we were in the middle of a pandemic. The backlogs on the probate cases was unusual, and that and that we only have one judge here in probate in Davidson County, so that was a backlog, and that is something that I think this court should take in consideration. That was not just a lack of effort on the part of the appellant. Further,
You
Your
said
Honor,
you presumed that filing that petition for an estate to be opened would essentially toll that 90-day time, right? Is that what you?
well, Your Honor, yes, it would. It'd be
Or
given
satisfy the 90
it would be somewhat given a favorable opinion when it came down to
Well,
determining.
did you go ahead and tell the court what you've done
Yes, Your Honor, I told
before the 90 days?
Yes, it was in my affidavit and in the response to the motion to dismiss.
Okay.
And
Let me ask, your motion for extension of the time, I know it was filed on the same date as a motion to dismiss, but were you aware at the time you filed your motion for extension that a motion to dismiss had been filed? You understand my question?
yeah, I understand your question. No, I mean, I wasn't aware that it had been filed. I, filed a motion for an extension and wasn't aware that it wasn't accepted by the computer system until I looked back several days later and found out it wasn't filed. It wasn't accepted by the system, so I refiled it. And I think that's clearly stated on the.
So your initial filing of the motion for extension was before the filing of the motion to dismiss?
It was, Your Honor, but the record in terms of the on the system does not show that it was filed. It was there. I had it on certificate of service where I sent out on that same day the motion to opposing counsel.
Do you know why it was not accepted by the clerk's office?
I never did determine exactly why it wasn't accepted. It was just, we were all trying to get new with this electronic filing, and it's just something I didn't know was rejected. Further, Your Honor, there was no prejudice to the appellee in this particular case, and that in the order issued by the trial judge, it's never reflected that there was any prejudice to the appellee in this case. by the failure to timely file the notice and ask for an extension of time in which to name a party as a substitute in this particular case. And that in the case of Warner versus Frazier, Your Honor, 17-112 Southwest 2nd, 109, the Warner court held that in instances of excusable neglect and where the opposing party has not been prejudiced by delay, Rule 25.01 of the Tennessee Civil Procedures should be construed in conjunction with Rule 602 to allow substitution of parties after the direct 90 days. As it is generally true, the kind of excuse that will satisfy this requirement is a function of the length of time that passed and the possible harm to the opposing party. In Douglas v. Estate of Robinson, the suit had been, in a particular case, the suit had been filed, the case that was even tried, and the court allowed the suggestion of, an extension of time to file, name a new party after 8 days. Even though the case had been tried and a verdict, and it was waiting on a verdict in that particular case. When reviewing the record in this case, the trial court failed to note the second part of the Warner court test, namely the possible harm or prejudice caused to the opposing counsel or opposing party.
Isn't under Rule, I think it's 6.02, isn't the court examined excusable neglect, right?
Yes, Your Honor.
That's really the focal point of the trial court's
Yes.
decision, and that was that there wasn't any, but you say there was, and what constitutes that excuse? The fact that you were trying to get the matter on the probate court's docket and couldn't?
Yes, Your Honor.
Okay.
Because without an order opening up in the state, we have no party. We do not have a party that could be before the court. Thank you, Your Honor.
Thank you, Mr. Clayton. Mr. Cates, we'll hear from you on behalf of the appellee. Good morning.
Good morning. May I proceed?
Yes, sir.
Taylor Cates of the Memphis Bar.
There seems to be a Memphis theme going on here.
It does.
Getting worried. Let me declare that I'm so old, I went to Memphis State University.
All
so
right.
not the University of Memphis, but Memphis State.
And I began my practice in Nashville.
I have nothing to do with Memphis.
Okay, and everybody from Memphis is thankful for that.
If I may start by addressing a question Judge Armstrong raised about, I don't know that it's legally relevant who won the race to the courthouse as between the motion to dismiss or the motion to enlarge, but the context of that is that we had a status conference, our second status conference with Special Master Nichols. In the first status conference, we specifically discussed that she had passed away, that a motion to substitute, or a suggestion of death had been filed, and that he had 90 days to file a motion to substitute parties.
Is that suggestion of death in the record?
I don't know that it is. We attached it as an appendix to our brief because as we were preparing it, we made the same observation that we weren't sure that it was in the record. And at the second conference, the first question was, has this been filed? And the answer was no. And she indicated, Mr. Cates, you have a motion to prepare then, don't you? I said, I do. So there was, regardless of which one of us typed fast enough to file it to get it into the court, the motion to enlarge was prompted by the recognition that a motion to dismiss was imminent. At common law, when a party passes away, the death results in abatement, and a suit, when abated, is dead. It stays dead unless it is revived by proper compliance with Rule 25.01. There's a 90-day window, and if it is not revived within that period of time, it stays dead, and the rule is mandatory. It shall be dismissed. Rule 6.02 allows you to move to enlarge time for a deadline such as this, and the standard is just good cause shown, or even it's granted with cause shown. After 90 days, though, it stays dead unless there's no prejudice and there's excusable neglect, which was a good reason out of one's control. The court needs a good reason for why a motion to enlarge wasn't filed timely. The facts that have been raised about why the plaintiff couldn't substitute parties, that there was some delay in finding the heirs, and that it took a while to get a hearing in probate court, were all facts that were known to counsel before June 17th, which is the deadline, which is not the deadline to substitute parties, but is a deadline to file a motion to substitute parties. So he didn't even have to have the estate opened by June 17th. If he had filed the motion, he would have been able to file the motion and indicate, I've got a hearing set on July 19th or whenever it was, which could have been done in the motion to substitute parties, or could have certainly been done in the motion to enlarge the time. That would have been cause shown, and I would be, I'm sure that motion would have been granted if it were filed.
Let me make sure I understand your argument, Mr. Cates. You're saying that even without having opened an estate and identified a possible heir, he could have simply filed a motion to substitute without naming that party that was going to be substituted in the motion?
I think he could, Your Honor. The simplest thing to do would have been to file a motion to enlarge, to say, give me some more time to get this figured out because I've got this hearing in July. But Rule 25.01 indicates that the motion for substitution may be made by any party or by the successors or representatives of the deceased party. I would submit that in the period of limbo in which the party has passed away and before an estate has been opened, the lawyer can stand in the breach and act on behalf of the entity that was Ms. Cunningham and that will soon be the estate of Ms. Cunningham.
Could he have filed for some sort of interim guardian ad litem, for example?
A public executor.
Public executor, yeah.
Absolutely. Absolutely.
Is this case considered a wrongful death action or slip and fall?
It is not. It is a personal injury case based on a slip and fall.
So there's no allegation in the complaint that the injuries resulting from the slip and fall led to the plaintiff's death?
Correct, Your Honor.
Okay.
And I am not. I'm not aware of any facts in the record.
If it was a wrongful death action, then a next of kin could step in as the substituted party.
Indeed. But that is not this case. The two facts that I would submit are relevant to the question of excusable neglect is that this is a rule that we don't interface with every day, but in this case we talked about it. It was specifically discussed and specifically entered in an order
Status conference.
in the status conference. And then Your Honor's point was correct, that the rule is clear that once a suggestion of death is filed, you have a specific window of time to act, but it is less clear about when you have to start the firing gun. Plaintiff's counsel had some control over when to start that clock, and you could either get your ducks in a row before you file it, or you get to a place where you know you're within 90 days of having your ducks in a row. Firing it is ultimately, they became the authors of their own misfortune, perhaps, by filing it when they didn't need to.
Let me ask you, Mr. Cates, the Tennessee Supreme Court's decision in Douglas versus the estate of Robertson seemed to suggest that a trial court should grant an enlargement unless there's a showing by the defendant that the defendant would be prejudiced by the enlargement. What prejudice do we have here?
I am not going to be able to identify any specific prejudice other than generally that cases stagnate if they're not moved forward affirmatively, but meaningfully there isn't any.
So there is no prejudice. Is that?
The defendant appellee cannot identify any prejudice as a result of that. I would submit, though, that that the rule requires that that's not the end of the discussion. If that were the end of the discussion, then the excusable neglect standard, when you're faced with a situation such as here, in which there truly is nothing being demonstrated that was a situation that was out of the appellant's control, you would define that standard down to nothing. If you grant relief for excusable neglect without any specific showing of anything that would constitute neglect that was outside of appellant's control, specifically in doing what needed to be done in filing a motion to enlarge within that period of time, then you have written the excusable neglect standard out of the rule altogether.
Anything further?
No, Your Honor.
Is there a transcript of the hearing where his motion was denied and your motion to
I don't
dismiss
believe
was
so, Your
granted?
Honor.
Okay. Thank you.
Thank you, Mr. Cates. We'll hear rebuttal from Mr. Clayton.
Mr. Clayton, do you agree that the suggestion of death was filed March 19th of 2021?
Yes, sir.
Okay. So both parties agree that that's when it was done?
Yes,
Thank
sir.
you.
Your Honor, the defendant has failed to establish that there was any prejudice as a result of the failure to ask for an extension of time. That is a two-pronged test to determine whether a appellant or a party has violated the 90-day rule, and that we filed the petition, and that the discovery and the case was ready to proceed. We had a party named that could very well assist in the prosecution of the lawsuit, and if you're looking at Douglas versus the state of Robinson, Your Honor, in that even if the plaintiffs were aware that they had 90 days, that we took action to try to get a party before the court. And And even if the plaintiff had indicated that we had not done what we were supposed to do, that we were supposed to have submitted an order asking for an extension of time, that would not have been any prejudice to the parties. And that
Let me ask you, what action did you take to try to get an earlier date to hear your petition to open the estate?
Your Honor, we did not take any action to get an earlier date. It was just that at the time required, it was just a backlog of cases, and we did not contact the court and ask for an earlier date. And again, Your Honor, we ask that this case be remanded back to the trial court, that you set aside the dismissal of this case and allow us to proceed in litigating this matter so that we can pursue justice in this particular matter. The parties have lost their mother. Let's not allow them to lose another matter regarding the loss of their mother.
But this isn't a wrongful death case.
No, it's not a
This is
wrongful
just a slip and
death.
fall case.
It's the slip and fall. Their claim for the tort action on the slip and fall, Your Honor. All right.
Thank you, Mr. Clayton and Mr. Cates, for your arguments. We'll take this matter under advisement.